Good afternoon. I'm Paula Clarkson from Merhab Robinson Clarkson, and today we're going to talk about foundational plans and demystifying them to make them easier for your kids or other family members that maybe don't need a full estate plan. So let's just talk about who needs plans. Basically, when someone turns 18, they can do a lot of different things that they weren't able to do when they were a minor. They can get married, sign a contract, which means buy a car, manage their own money, make a will or a trust and other estate planning documents, as well as vote and basically just control their own lives now that they're an adult. And if you have minor children that are turning 18, that becomes a problem. It's a big transition. My daughter just turned 18, so we're trying to navigate these fields on what she can do now as an adult and what I have a say in and what I don't. And it's a new world for everyone involved. So the world consists of basically finances and families. So, as an 18-year-old or older adult, you have assets. You may have liabilities since you can get credit cards now, which is really scary. Who has access to your information, personal information, what are your needs and responsibilities, in addition to taking care of your family, your healthcare decisions, knowing what their preferences are, should something happen to them, because now they have control. Okay. Sorry about that. We're having some technical difficulties. Let's talk about also what could go wrong. Perfect timing. We have, when you're 18, your parents can no longer make medical decisions for you, and they can, the children, now that they're adults, can make their own decisions. They can be sued for that car accident, managing their money, and even join the military, which is a very important decision, but they're allowed to make it on their own. So ways that we can help protect your children and make them more responsible is getting a foundational plan for them in place. So we call a foundational estate plan a HIPAA authorization, a healthcare directive, and a durable power of attorney. It's foundational because that's the start. And we'll go through whether someone may need a will or a trust at the end, but this is starting the foundation. And most of what I'm talking about is going to apply to, the young adults that are just turning 18, but it can apply really to anybody. It could be a 30-year-old, a 50-year-old, a 70-year-old. A lot of our clients' parents don't have assets that qualify for the threshold of probate, so maybe they don't need a will or a trust. But having the basic foundational plan in place is very helpful. But it makes, for illustration purposes, it makes a lot more sense for 18-year-olds, especially with the transition, when they really are relying on their parents still for a lot of things. So the hypothetical, let's say that your kid is going to Texas for spring break. They're driving across the country with their friends and there's a car accident. You get a call from one of the friends saying that your child has been taken to the hospital and they want to let you know. So of course you're going to be upset, wondering what you need to do, trying to find out where they are, try to talk to the doctors. But there are some limitations. If the child is now an adult, then you may not have access to anything. Technically, hospitals are not legally allowed to release the medical information of the child once they turn 18. We've had that situation here in our office with my business partner, and her son was in the hospital after an accident, and he was unconscious for a little while. The hospital would not disclose any of his personal information. So it was a very scary couple of hours for them without getting that information. But the hospital is right. Legally, they don't know if the people are the right people, if he has relationship with them, if he would want any of his private medical information shared with them. There are hospitals, we've had cases where they will talk to you, but that's not really the time you want to be finding it out. The hospital may not even say if your child is a patient there, what they're being treated for, or anything. So having that information, the healthcare directive and the HIPAA is very, very important. So what are the different documents? A HIPAA stands for Health Insurance Portability and Accountability Act. It's a law under federal regulations as well as California law. And it basically provides that anyone age 18 or older, their medical information is private unless they authorize it to be released to people. So this could be insurance companies, it could be the dentist, it could be the doctor, it could be anybody. So any of your personal information should not be able to be released, even if the kids are on your health insurance. So you could be the one paying the bill. It doesn't matter. Their private medical information is protected, no different than yours or mine are. We wouldn't want random people being able to come in and finding out about our personal diagnosis. So with the HIPAA authorization, you are able to name all the people that you want to be able to have your medical information released to. So you could name, definitely want to name the people that are your healthcare agents, making those decisions for you, people that can talk to your doctors and get that information. So it could be people that are not also on your healthcare agents. So for example, my husband is the one that is listed as my healthcare agents, but my daughter is still able to talk to the doctors. My parents I have listed on there so that they are able to talk to my doctors. Now they are not decision makers under the healthcare directive, which is a different document. They can only get access to the information because of the HIPAA. So that's going to be the biggest difference between the two. So the healthcare directive, on the other hand, nominates who actually makes medical decisions for you when you are unable to make those medical decisions for yourself. So if you're incapacitated, you're in a coma, you have dementia, who is acting on your behalf to make those decisions for you? Do you want life support? Do you want to donate your organs? Do you want to be buried? How do you want pain relief? What kind of treatments and things do you want? Are they authorized to institute surgeries or hospice care, long-term care, different things like that? It's basically someone stepping in, and they can only make those decisions if you are in a position where you're not able to. So going back, contrasting again, HIPAA, your medical information can be released to the person, but the healthcare is who's actually the decision maker and what decisions they can make. The third leg of the foundational plan is a durable power of attorney. Because with the HIPAA and the healthcare directive, we dealt with the personal needs, where they're going to live, medical needs, and so forth. But the durable power of attorney is who makes the financial decisions for you. So even if you have a team, they may qualify for some government benefits or Social Security, or they may have a paycheck. A young adult starting a new job may have a 401k plan. They may have some savings. They may have a car payment that needs to get paid, credit cards, taxes, different things like that that may need to be taken care of if they were incapacitated for a period of time. And then obviously our older parents, as they start to decline, they may need some assistance with paying their bills and dealing with their taxes and helping control their assets. So this is where the power of attorney comes in, all things financial, to take care of that. Another thing, when you have college-age kids, there's the Family Educational Rights and Privacy Act, the FERPA. So this is saying that basically when your children go off to college, that even the information that they have at the educational institution is private and protected unless they give you the rights. So, my daughter actually, just enrolled in college, and her school is great. They have a website where it has everything, and she was easily able to add me and her father on there so that we can look at the billing, the transcripts, everything we need regarding her grades, and so forth, financial aid and so forth. So it was very easy through their system to be able to go in and sign in, giving us that authority. So that's really important because we all know that the kids aren't always, gonna hopefully, pay attention to when those deadlines are for when the student aid needs to be paid, when does the tuition need to be paid, and the parents can able to go in there and also make sure that they're getting the grades that you had discussed with them to make sure that they're fulfilling their end of the obligation as well. So if the school has that, double check it. If not, there are separate releases for FERPA as well, so that the student can release that protected educational information. So the foundational plan is everybody needs this. We think, honestly, if you're 18 and over, it's necessary for you. Then we start building on an estate plan. Do you need a will or a trust? And in California, our probate threshold just got increased to $208,850. So that means that if my 18-year-old daughter passed away and she has $500 in her checking account, we do not have to go through probate. Anything up to the $208,850 level, we don't have to go through probate. By operation of law, her father and I, as her heirs at law, are entitled to those assets. If she was married, there would be the spouse, or if she had children, we look at those situations for who the heir at law is. So, if you have a young adult starting out in a job, they may have a little bit more in their checking account. They may have a 401k. As long as we're below that limit of $208,850, then we don't need technically a will or a trust if the person is okay with their assets going according to California law. But sometimes, my daughter might say, hey, I want my assets to go to my best friend or over to a charity of my choice, not to my parents. And in those cases, then we can always do a will. By having the will, we're not going to go through probate of the 208, unless it's over the 208,850 level. But at least it's saying who is the beneficiary. Also, another way to handle it is to name a payable on death beneficiary, or sometimes referred to as a transfer on death beneficiary. So very similar, if you have like a life insurance or a 401k or an IRA, you have a beneficiary. You can do that, a beneficiary designation on most accounts, a checking account or an investment account. The child would just have to check with their financial institution to see if they can do that POD or TOD beneficiary designation. I know we have in our family, some of the kids have named their siblings as the beneficiary. Just go, let's make it easy. It'll go to them, and we don't have to worry about it. But once you start getting to that 208,850 level, then we want to be looking at possibly a trust. Because there's obviously more assets, there's potentially more liability and other issues that need to be addressed. And basically having the trust is going to avoid probate of those assets and will allow the decedent person to designate who they want their assets to go to and who is going to manage their assets. And then as we have young adults or even the older generation, if they have IRAs, Roths, 401ks, those don't go in a trust, but we're going to name a direct beneficiary on those, whether it's an individual, it could be charities as well, and different percentages as they choose. So, we always are going to start with the HIPAA, the healthcare directive, and the power of attorney, and then we have to make the decision of at what point do we go on to the next. So we have a lot of college age kids that we're creating right now as they turn 18, 19, 20. We're doing the healthcare power of attorney HIPAA, and then later on, as they start getting their first job and then they have accumulated more assets, now they have a car, they may buy their first residence, then we will add on to the plan. Now, all of these documents, the healthcare HIPAA, power of attorney, will, trust, are all revocable while the child has capacity. So the expectation, I would say almost everyone that we've done, the child has named their parents as the decision makers. But the expectation is if they get into a long-term relationship or get married, that they would name their spouse as the decision maker for them. So those things can always be updated. They're not going to be forever under mom and dad's thumb, but they can make their decisions for them the rest of their life. So when we want to develop the foundational plan, it's actually really easy. What we usually request is that to have the child call in, we usually have a quick 30-minute call or Zoom, because a lot of the kids are off at school. We talk to them about their goals and who they want to have their assets, who wants to make their decisions, and things like that. Once we've gone through that with them, then we'll draft the documents, send them to them to take a look at. And if they're going to be back around here anytime soon, a lot of times we'll do this when the kids are on spring break or summer break or for the holidays, and they'll come in and we'll get them to sign everything. Or if there's a need, we can always send it to them and the kids can take the documents to their local FedEx or UPS store to sign them. And then we want to make sure that once they have those documents in place, really for anybody, that you're sharing those with at least your first agent. Going back to my hypothetical at the beginning, if the parents, say the child did have a foundational plan, but they left a copy at their dorm or at their apartment, and now they're on this road trip, and the parent may be technically the agent, but once they're calling the hospitals may start asking for proof. And if the parents don't have a copy of that, then they're out of luck. They may not be able to get to the child's apartment, or, maybe the child lives in a different state already because of school and things like that. So we always recommend that at least your first healthcare agent, that you send them the documents, and really the HIPAA to anybody that you're comfortable with being able to have those documents, so that if there is an emergency, those documents are readily available. I have my family members, I just email them to myself, save them as a document on my phone, so that if those situations ever arise, I always have my phone with me. Or, I pick up and I drive straight to the hospital, not thinking to grab any documents that I know I always have them with me. So, and it's also a good idea to share with the doctors and financial institutions, but again, that doesn't help necessarily, like if you're in the road trip situation, because these doctors in another state may not have access to those types of records. So always making sure the right people have access to them to be able to act on them. And, I always say that, at least the healthcare agents, the healthcare documents, share those, the HIPAA, the healthcare directive. And money can usually wait, that's not a big deal, but access, getting in there, being able to make the decisions, being able to talk to the doctor, those are things that usually have to be done immediately. So making sure that your family members and the people you have named definitely have access to those right away. So just wanted to see if anybody has any questions. I know today was really short and sweet, and that's why it's a foundational plan, because it's the biggest starting point, and getting everybody going. So I do have a couple questions. The first one says, what happens if an urgent care nursing home refuses to accept the valid durable power of attorney and advanced healthcare directive? Then I would, unfortunately, they would have to be sued. I have not come across anybody not accepting them unless there was maybe, let's say it was an older parent and two different children came in and had different documents. But technically, it's the one that was executed last is usually the prevailing document. So they, otherwise they could be sued for failing to comply with the legal documents. And then I have another question about, are we going to be sharing the slide deck and the recording? Yes, if you attended the webinar or didn't, we're going to be mailing it out via email and sharing it. We also post all of our webinars on our website at mrclawcorp.com, as well as our YouTube page, because we've been doing these every month. So we're going with different topics, and there might be other topics that could be of interest to you as well. But again, just recapping, having the foundational plan is very important to get everybody started. And at least making the basic healthcare and financial decisions for you, your children as they become adults, and you can start helping them out with things. So there we go. If you have any questions, feel free to email us after the webinar too, if anything is specific that you want to be addressed in your own specific situation. A little bit of information about me. My email address is paula.clarkson@mrclawcorp.com if you have questions. And if you have any other questions regarding any other areas, our firm's focuses primarily on estate planning and business planning for all of our clients. And if you have another area of law that you have questions about, we're always happy to assist you with a referral to someone that can help you with that. Oh, I'm sorry, really quick, I got 2 more questions that I want to be able to address. It says if we don't record the trust transfer deed to keep the revocable trust in stealth mode to prevent lawsuits from possible accidents, is it still valid? I'm a little bit confused about that. Trusts do not need to be recorded. So, but when you're transferring real estate into the trust, the preference is that you record the deed. I think the question is that you don't want to record the deed necessarily because if someone did a search on your house or your name, they might come up with the deed and thus obviously realize that you have a trust. There have been people that will file their deeds late. It's a little bit outside of the scope of our webinar today. But in the end, if someone's going to sue, they're going to subpoena your documents. They're going to depose you. They're going to find out if you have a revocable trust or not. So I don't think that that's the biggest thing that you should be worrying about if you're in a lawsuit. I would do other asset protection measures before not filing a deed to my house, putting it in a trust. And then there's another question about qualifying for Medi-Cal. That is outside the scope of this. Our office doesn't focus on Medi-Cal planning, but we do have a lot of professionals that are in the Orange County area that we can refer you to if there is a need for that. So again, if you have any questions that you would like to have us address specifically or anything else regarding any of these other areas, we would be happy to help you. Otherwise, I'm going to give you back some more of your time today, and I hope you have a wonderful day. Thank you.